So let us talk about intellectual property or know your rights. So what we are going to see, law governing IP or intellectual property, meaning type of IP like patent, trademark and copyright, infringement and action against these infringement, case studies and then conclusion. WIPO or World Intellectual Property Organization was established by WIPO Convention in 1967. This WIPO is specialized agency of United Nations and it promotes the protection of IP throughout the world. The headquarters is in Geneva, Switzerland. On April 26 every year, we celebrate this World Intellectual Property Day. This is how some celebration pictures are for you. So what are the intellectual property law in India? There are many big and small intellectual property law firms worldwide, like in India, US, UK, Chicago, etc., providing qualitative help for inventors and creators of product. So in India, this IP rights are safely protected and controlled by a well-established statutory and judicial framework. So apart from that, there are many attorneys and law firms of IP in India in various states. IP is a property that arises from human intellect. So it is a product of human creation. Intellectual property is comprised of two distinct forms. First of all, it is literary and artistic work. The second is the industrial property. So there are books, paintings, musical compositions, plays, movies, radio, TV programs, performances, and other artistic work. So how are they protected? They are protected by copyright. So IP describes physical matter that is the product of an idea or the concept for commercial purposes. So how are they protected? By patented objects, trademarks, industrial designs, trade secrets, layout designs and geographical indications. There are various types of IP. Major of them are functional and technical inventions like Patent Act 1970 amended in these years. Purely artistic work which are governed under these acts, a symbol, logo, word, sound, color, design, etc. under these acts. So if you don't see a problem with this question, you need the class. Why? All I asked was, can I patent my copyrighted trademark? Patents. Let us start with patents. So it is covered under the act called the Patent Act 1970 and it was amended in 2005. So it extends to complete India and it shall come into force on such date as the government may publish by the notification in the official gazette. So what is the patent? The definition is, a patent describes an invention for which an inventor claims the exclusive right. So inventions are patentable only if they are new, means novel, they are useful, they are not obvious, they pertains to patentable subject matter. Patentable subject matter means invention. It relates to a process or a product or both. It involves an inventive step and this invention be capable of industrial application like a machine. What are the life and duration? Okay, the numbers which I'll be speaking to you, this is the time which I'm making this video. So maybe when you are going across this presentation, these numbers might have changed. So kindly see the latest one for that, Wikipedia for sure. Now the term of the patent is around 20 years from the date of filing for all types of inventions. The priority date is for first to file, who first filed, and the date of patent is the date of filing the application for the patent. So the term of the patent is counted from this date. These are the government fees. The government fee for filing a patent application in India is 750. Please see the latest one. And for individual and 3000 for the legal entities. And no fees for first and second year. There is a renewal fee on yearly basis which is required to be paid from 3rd to 28th of for keeping the patent in force. And this patent lapses if renewal fees is not paid within the prescribed period is also admissible. So is a patent granted in one country enforceable in another country? No, there is nothing like global patent or a world patent. Patent rights are essentially territorial in nature. So granting a Patent in one country of union does not force other countries to grant the patent for the same invention. The refusal of the patent in one country does not mean that it will be terminated in all other countries. What are the numbers of patents in India, or who are the patent holders in India? The list of top 10 patent holders in India comprise only pharmaceutical and biotech companies. In India, 184 patents are held by the Council of Scientific and Industrial Research (CSIR), followed by this Ranbaxy. While the top 10 patent holders across the world are IT companies, in India, no IT firm has patent. Maybe if you see the latest one, there will be. He is the youngest patent holder on wheelchair, Jaipur, drawing inspiration from scientist Stephen Hawking. A wheelchair-bound 9-year-old boy here has invented a game of 6-player circular chess. The boy is called Hridayeshwar Singh Bhati, has got the game design patented in his name. This is how the certificate of grant of patent is provided. Differs from various country to country. Now coming to trademark. So this trademark, it is covered under the act called the Trademarks Act 1999, and the act came into effect in 2003. It replaced the Trade and Merchandise Act 1958. So it extends to complete India, and it should come in force again by the Gazetted or Gazette of India. This trademark is a symbol or a logo or a word or a sound or a color or a design or other device that is used to identify a business or a product in commerce. So different symbols are like this T, M, S, M and R. So this is intent to use application file for a product, intent to use application file for services, and this is registered trademark. Here are the registration procedures: application for cert, application for registration, examination of trademark, advertisement of trademark, and filing of opposition and certificate issued. The trademark is valid for 10 years from the date of application, which may be renewed further for 10 years on payment of prescribed fees. Service mark rights are reserved exclusively for owners for 17 years, and it can also be renewed. The government fees is around this much for each class of goods or services. Please see the latest one. So a trademark is a sign used on or in connection with the marketing of goods and services. Used on the goods means that it may appear not only on the goods themselves but on the container or a wrapper in which the goods are when they are sold. So these are the correct uses. Raymond Textile in India is leading producer of fabric with over 60% market share. Raymond Textile in India is leading producer. Okay, see how it has been changed. Raymond Textile. This is the correct use. Or in India, leading producer of worsted or safe fabric with over 60% market share. These are the correct uses. And how is the incorrect use? Just like that. You cannot use this because this Raymond Textile is actually, you need to provide the surrounding text to set apart from other text. These are the specification or specifying font size, proportion and placement. This is the correct use. This is incorrect use. You have to use like this, not like this. This is the correct use. This is incorrect use. And do not change spelling. These are the correct use for Calvin Klein. Don't change the spelling. Tommy Hilfiger, don't change the spelling again. For other one also, don't change the spelling. These are the trademarks. Like you have a name, you have a logo type, you have a symbol, you have a slogan, right? And this is the shape. This is like color. And the copyright, the third one, the Indian Copyright Act 1957, amended latest in 1999. The meaning is it is a right which grants protection to the unique expression of ideas. The term original in the copyright law means that the work originated from the author. So there is no requirement for novelty or uniqueness, as there is what is in patent law. So copyright law protects the expression of an idea, not the idea itself. So what is covered by copyright? Literary, films, dramas, musics, artists, and sound recordings. What is not covered by copyright? Again, ideas, facts, recipes, works lacking of originality like the phone book, the name, titles of short phrases. These are not covered, sorry. Registration procedure, register a copyright by completing a simple application form along with appropriate field. Need not send a copy of your work, it may appear with the same title, but if each work has been created independently, each will have its own copyright protection. Then the duration of copyright. The copyright lasts for author's lifetime plus 50 years from the end of the calendar years in which the author dies, 50 years for the films and sound recording, 25 years for typographical arrangements of a published edition, and copyright protection always expires on the December 31st of the last calendar year of protection. What is fair use? Gives permission to use copyrighted material if certain criteria are met, protects freedom of speech, and promotes public benefits like education. These are the fair uses. And beware of these fair use excuses, because never assume that your use falls under the fair use exception. Save money is not a sufficient excuse, and laziness can be a trap. How much can I use? Photos and images, up to 5 works from one author, up to 10% or 15 works, whichever is less from a collection. And database information up to around 10% or 2,500 fields or cell entries, whichever is less. Now infringements. How to take action against these infringements? What constitutes infringement? First of all, any reproduction, use, distribution, performance, etc. of the work without the permission of the owner. An identical or substantial similar reproduction is also covered. And infringement, damages, and injunction, these are also covered under infringement. So suit can lie in the district or high court. It may issue an injunction either to prevent the infringement from any other further use, or award damages to the patent owner, or will pay the patent owner royalties for further use. So Apple sued HTC over iPhone patents. Apple sued this HTC and has filed a complaint against to US International Trade Commission, alleging that the Taiwanese companies is infringing 20 Apple patents related to the iPhone. Steve Jobs, Apple CEO, said in his statement that we think competition is healthy, but competitors should create their own original technology, not steal from ours. These are the remedies for trademark infringement. A suit can lie in the high court or a district court. Punishment extends from 6 months to 3 years, a permanent ban on engaging in commercial activities. See, these are the example of successful civil enforcement action. 3 suit filed against Adidas, Salmon AG in Delhi High Court against counterfeiters. At the initial stage, infringing goods were seized by the local commissioner, and cases were decreed recently, and damages of around 15 lakhs was awarded to Adidas Salomon. These are the remedies for copyright infringement. A suit can lie in the district court or in a high court. They're punishable for 3 years. These are the copyright claims on the basis of underlying artistic work. This is Ritika Limited versus Ashwini Kumar, Ritika Limited versus Neena Talukdar, Ritika Limited versus this Sajid Mobeen. So, what I didn't know, these are called innocent infringements. These occurs when infringer was unaware that things were protected. No excuse if works properly displays patent, trademark symbols like R, T, M, S, N, copyright notices like C, name, year, and like Utsav Sarees or copyright 2011-12. These are all. If these are there, and if you are using it, sorry, you have no rescue. So conclusion is, create yourself rather than using others' creation. Do not use competitors' mark in such a way that it harms competitors in an unfair way, and no comparisons that are likely to cause confusion. So technological advancement made the job of the creator easy, so it also made the job of the copier easy. Thank you so much. Take care.